Law firm partnership buy-in loans. Key considerations. Law firm partnership is a strategic financing solution for many law firms. LTP programs allow law offices to take on new partners without having to commit to significant startup funding for operations and accounts. In this instance, the partner purchases shares of the firm's stock at an agreed-upon price from the sponsor. The share is then issued to the partner as compensation for their services. Partners enjoy several advantages to this arrangement. The partners stand to make substantial earnings when they purchase shares of the firm's stock. It is usually the case that a partner will be paid a percentage of the sales. The partnership agreement may specify that a partner receives 1/3 or 1/2 of the profits from the sale of each partner's shares. Most law firms use a portion of their equity as their partner compensation. Benefits of law firm partnership. Law firm partnerships can provide significant cost savings for the firm. Typically, partners are paid a lump sum amount when a partner is hired or when the partner retires. If the firm buys shares from outside funding sources, it will pay expenses related to obtaining those shares and paying the income taxes related to them at the appropriate time. Once a partner is terminated, there is very little expense related to that termination. The total cost of retaining a partner is also much less than the cost of hiring and training new staff for the firm. Many law firms have used partner buy-in loans and deed of trust buy-in loans to finance their ventures. Most of these transactions are leveraged buy-in loans. They are generally considered debt financing because the firm finances the purchases using one of its funds rather than issuing credit lines. Partnership loan. Buying into a small law firm. A partner buy-in is similar to the purchase of an interest-bearing investment. In most cases, the partner will receive all of the money paid to him if he sells the stake at the end of the partner's term. If he receives payment from the buyer of his interest, that sale will be treated as a debt for the business. The primary benefit of partner buy-ins and deed of trust buy-ins is that they create additional capital for the law firm. The value of the capital created by these transactions, however, is dependent upon the performance of the partner. The partnership agreement may specify the price that must be paid to the partner if he becomes unemployed or if he sells at the stake before the end of his partner term. If the partner performs poorly enough that he is unable to continue as a partner, the value of his investment may decrease. On the other hand, if he performs exceptionally well and the business succeeds, the value of his investment increases because he is the only partner who is responsible for the purchase. How do you finance buying a partnership? Equity partnership buy-in. To ensure that the firm can utilize the funds generated through partner buy-ins and deed of trust buy-ins, investors must use good judgment when making decisions regarding their investments. Investors should examine each deal critically to determine if they are financially sound. They should also consider the overall profitability of the firm in terms of return on investment and operating profits. Also, they should consult with management and ask questions about strategies that have worked successfully for other investors in the same industry. Management will be willing to provide information, but will not provide specific strategies. Investors must be aware that a partner buy-in does not guarantee that the firm will succeed. A partner can't purchase all of the shares of the partnership to raise all of the capital needed to finance the firm's operations. Instead, the partner must rely on outside investors and use a combination of cash and partnership credit to finance the firm's projects and operations. Talented lawyer going the partnership route. Investors should not depend on the ability of the partner to make money alone. When an investor is willing to partner with a law partner, he or she should be prepared to partner for the long term. Law firm buy-in loans are typically issued based on 1 year of operation. Some firms provide up to 10-year financing terms, but these are uncommon. It is usually not possible to obtain financing over the long term, so most firms will seek to finance through cash and partnership arrangements for at least 1 year. The long-term commitment ensures that the firm will have sufficient cash resources to execute its projects without any significant interruptions from outside funding sources. Investment loan for lawyers. An investment loan for lawyers is available to lawyers who have an established legal practice. The money can be used for various reasons, including overhead costs or investment purposes. This type of investment is different from a line of credit or a debt instrument in that the cash investment is made with an anticipated repayment date. A lawyer can use this type of term investment objective for a variety of purposes, including paying off bills, building a client list, funding the startup of law practice, or buying property. The money may also be used for funding retirement. An investment loan for lawyers is a smart investment because it gives lawyers some security during economic times when the banks are less willing to lend money. Law firms are particularly sensitive during certain years when there are high unemployment and inflation. With the downturn in the real estate market, lawyers are finding that their clients are not able to pay off their debts when banks refuse to lend money. Law firms need to turn to other sources. Source of reliable income. The law has long been a source of reliable income for those individuals who can practice well. The only problem with this income is its lack of collateral. However, that problem can be solved by a risk investment loan for lawyers. The investment will be made with an anticipated return date and will result in either a lump sum line of credit or an annuity. The amount of the investment loan for lawyers can range from several $1,000s to several $1 million. Fixed interest investment loans. In case his liabilities are higher than his assets, then he may opt for a fixed interest investment loan. Depending on the lawyer's needs, he can also receive an annuity. These investment loans are offered by several finance companies and brokerages. Many investment loans for lawyers can be found online. The investment process is quick and convenient since the lawyer gets his funds almost immediately. Once he receives the funds, the lawyer can use the money to assist his clients with cases. Since there are many options available when it comes to investment loans for lawyers, choosing the best one will be a challenging task. Some of the important factors to consider include the size of the investment loan, the interest rates, and other costs involved. Once lawyers find the right investment loan for them, their incomes will increase drastically. They will be capable of helping their clients resolve their legal issues in a timely fashion, enabling them to live their legal rights. Do partners in law firms have to buy in? Many small business owners ask, do partners in law firms have to buy in if their partner's firm wants to raise financing? The simple answer is no, they do not. Partners in a law firm do not typically have to buy in or commit to the firm if they are acting as investment bankers or investment partners. However, when the firm is actively seeking venture capital funding and/or private equity, it is common for partners to assume a buy-in as one of the responsibilities of being involved with a firm. Buy-in can be assumed by a partner when a firm decides to raise a series of venture capital or private equity funding rounds. The partner will typically act as the facilitator between the venture capital firm and the partner which are offering the capital contributions. In some circumstances, the partner will provide 100% buy-in, and in other circumstances, the partner may require that a percentage of the capital contributions be held by the partner as a use funds policy. Cash contributions to improve cash flow. Once an arrangement like this has been determined, then it is time to determine if the partner will require upfront payment in cash contributions, which are referred to as a use funds policy. Most venture capital firms and private equity firms require the purchase of partial ownership interest from their partners. This will be called a buy-in and will oftentimes require that the partner subscribes to a cash reserves management note. However, many firms will allow their partner to invest the money into an investment vehicle without having to subscribe to a note. When firms determine if a partner will require buy-in, they will typically look to see if the partner's firm has a history of partner involvement and success. Please give us a call at 653-0124 if you have additional questions.